we're going to be glad that we are condensing trial day 7, which was Friday last week, right before Snowmageddon. Remember, the court optimistically wanted to get that done, and that didn't happen. The defense on Friday, January 23rd, knowing that the court was trying to beat a snowstorm so that this case could be done, took the most painful amount of time to do everything. It seems the defense has some type of PowerPoint, but it's not really, but it is. And it's just showing like screen caps of different things, including map plot points. But when they are dealing with map plot points, they have a screen cap of the plot point, but not where it was derived from. So instead of saying, here's the map plot point and here's the data it came from, they just had a map plot point and then asked the expert, well, where did this come from? He's like, well, it either came from this extraction, or this extraction. Guess what? That's not adequate foundation. You have to tell the prosecution where it came from. And at one point on Friday, the defense, who is marking each and every page of the PowerPoint separately as its own exhibit, as they're doing that, they have a page with the screen cap, and then the next page has something circled. And if you remember 100 million years ago, when the prosecution's expert had the photos from the crime scene and was trying to circle them, and the defense was like, no, she didn't make the circle. The computer made the circle. And then the prosecution was like, okay. And then grabbed different fresh screen caps and then had her circle them on the podium. So at one point in the day on Friday, the defense goes to admit it, and the prosecution says, well, he didn't make the circle himself, but we don't have any objection. And I was like, damn. So the defense expert on Friday is still on the stand. They have not gotten to cross-examination. I have a lot of issues with the testimony, and my issues with this expert's testimony is that I find some of the PowerPoints to be incredibly misleading because they are not labeled. And my frustration with this expert is that he is saying that certain things are from the laptop and certain things are from the cell phone, and almost trying to merge that user activity together. Someone can be on a computer and someone else can be on a phone simultaneously in different parts of a home. Yes, someone can also be on their computer and on their phone at the same time. But it is hard for me to understand how you're saying on the laptop, somebody's creating the FetLife account, and on the phone, somebody's Googling like Lululemon leggings and Frozen, the musical tickets, and they're on the laptop and on the phone together at the same time. So as this expert is saying that he believes that it was Christine Banfield that created the FetLife account, that she's the one that created the Gmail account, that the user activity shows she never lost control of her devices, he's saying things like, well, there's this activity on the phone and this activity on the laptop, but on the screens they are showing, the information is displayed the same way. So the information from the laptop and the information from the phone are displayed the same way, but it's not labeled where it's coming from. And I find that to be difficult to follow and misleading. And there is a point that we are going to look at today when that became apparent, but it's a frustrating slog of testimony.
What's on here is on here exactly the way it was when the device was either imaged or acquired, when Detective Miller did it back contemporaneous to the event back in 2023.
Based upon your review of this data, were you able to draw any opinions related to this case?
I was.
And what were those opinions?
That catfishing did not occur.
And did you produce any
So that is the headline of this expert's testimony that went on for almost the entirety of the day Friday and is still going today. And each time he discusses it, he talks about not losing control of the devices. There is a period of his testimony that I'm going to summarize before we jump to the next part of his testimony we're going to cover. And the first thing that they looked at is the creation of the Gmail account that corresponds to the FetLife account. And he makes the conclusion that whoever's in charge of the Gmail account is in charge of the FetLife account, is in charge of the Telegram. That conclusion I don't disagree with, but I think more than one person can have access to that Gmail account. And the question that I have that has not been answered yet is, did Christine Banfield's cell phone ever access the second Gmail account? And they are going to refer to it sometimes as like the subject Gmail account. There are two Gmail accounts, just so you guys have them in your mind. The one with the numbers in it is the one that was created second in January. The one without the numbers in it is the one that it seemed that Christine Banfield uses her personal Gmail account. So the first swath of information that this expert goes over is that on January 17th, Christine Banfield took a selfie of herself in a swimsuit. It was a full swimsuit. The selfie looks like it was in maybe a gym locker room where there was a pool. There's a Little Mermaid pool toy on the counter. And she Facebook messages that photo to her husband with the title "New Swimsuit." Later that night on her laptop is logged in. They do not say if there's multiple profiles or not, but her laptop is logged in at 9:59 p.m. Then the Gmail account that is her normal Gmail account is accessed. They do not say if it's logged in or not. They do not say if the tab is open and it's accessed. And what was interesting to me is that when the inbox was accessed, whoever accessed it looked at the inbox briefly, looked at drafts, and looked at sent mail. When's the last time you've looked at drafts and sent mail in your own email account? Just let me know. So the email account was accessed, looked at draft, and sent mail. Then Facebook was accessed. We'll come back to that later. Christine's Facebook. Then the suspect email is accessed. Then the FetLife account is created. He uses that series of events to say, look, Christine was on her personal Gmail account checking her sent mail. And then she was on her personal Facebook account. And then all of a sudden, the FetLife account is created with this other Gmail account, and this other Gmail account is logged in. And he's arguing that that period of time is too close for Christine to be on the Gmail account, Christine to be on the Facebook account, and then Christine's computer to be taken and have the FetLife account created. Nowhere in that does he leave the possibility that someone else had the login for the computer, looked at the sent messages, and then looked at Facebook. I have a theory about that, but I'm going to see where we go in cross-examination. And then the email for FetLife is accessed, then FetLife is created. In addition to that, the Facebook Messenger is accessed at 10:30. And Facebook Messenger is accessed with the photo of the bathing suit. That photo is downloaded. The fake Gmail, or the second Gmail, the subject email, then takes that bathing suit photo and emails it to itself. So the photo, somebody grabs it from Facebook Messenger. Who knows it's in Facebook Messenger? Well, Christine, because she sent it. Who'd she send it to in Facebook Messenger? Her husband. So the computer downloads the photo, the Gmail with the numbers in it emails the photo to itself. That photo goes through an editing program. No discussion of whether the metadata was removed from the photo in that editing program. We don't know. But then the metadata shows that it went to a photo editing program. And then that photo was uploaded to the FetLife account. All on the same night. My question being, if it's your photo from your phone, why download it from a Facebook Messenger? But the expert keeps saying, look, Christine, and the prosecution keeps objecting and saying user, look, Christine is on her Gmail account. She's on her Facebook account. And then there's no time for the computer to get yoinked and for the CBRN account. And he bases this on Juliana's statements and says, well, Juliana said that when they were on the laptop, they only accessed the Gmail account, the FetLife account, and Telegram. I think what the defense is doing by spending multiple days with this witness is the defense has now gotten so granular, the defense has actually almost pulled the jury in to say, we're going to prove to you that it was Christine on her devices. But that invites the juror in their mind to go, well, you didn't prove to me it was Christine on the devices. The defense doesn't have to prove anything. But now that the defense is saying to the jury, we're going to prove to you it was Christine on her devices, the jury's allowed to hold them to that. The defense doesn't have to do that. But it feels like they're trying to. It feels like they're trying to pull the jury along with them to say, look, it was Christine.
What I see is Ms. Banfield's laptop is in use with a remote access to a website associated with her work. The activity on this device began while other devices weren't in the house.
Judge, I'm going to object. That calls for speculation.
Sustained, we need to stick to devices.
Okay.
I thought I said devices.
You said other people in the house.
I thought I said other devices in the house. My apologies.
Well, let's just say what you meant to say, and then we'll
So this is a current time when other relevant devices are not in the house. And the
And Judge, I'm going to object as to foundation. This slide indicates that the website is a Chrome last tab. The witness is assuming that it's being interacted with, but that is inaccurate from the information on the screen. I do not believe he's laid any foundation to suggest that there is an actual interaction with this website occurring at 11:07.
Foundations.
Okay. Sir, what was the basis for, this is already in evidence, correct, Karen?
It is.
Yes.
What is your basis for your assertion that this was a law?
She's just started her cross-examination in her objections. And I'm not even mad at it anymore because you know what? Also fair.
Login. Access.
It's a fair point.
What did you just say when she said this is a last tab and we have no information about whether this tab is being interacted with? What did you say? Your response to that was?
Access.
It's a fair point. I can't tell what happened past this. I cannot tell if a user went forward with accessing the site beyond just visiting, just getting to the page.
That's what you just described on this particular exhibit is in UTC time.
Correct. So it's just corroboration. We have Telegram activity on the laptop, and we have a Telegram conversation occurring contemporaneous to each of the instances of activation of Telegram use.
And I can go back to the other slide that you were referencing.
If you think it would be helpful, I'm fine.
Sir, what were your conclusions based upon your digital forensic analysis of February 20th, 2023?
I didn't see anything here to suggest device takeover. I didn't see anything here to suggest misattribution.
Thank you, sir.
So he is saying, I don't see anything here that suggests misattribution. I don't see anything that suggests that the person using the device is not the person who says they're using the device. And that continues throughout the entirety of the testimony. He also talks about the two-factor authentication and says in his testimony that the text messages from the two-factor authentication weren't all the way deleted, but it was very difficult to understand as he was trying to talk about whether or not somebody would have seen them when they opened their text. Because remember, Juliana said when they got the two-factor authentication for Telegram that Brendan Banfield went and deleted it. But as he was trying to explain that it wasn't deleted and somebody could see it, it was unclear to me because we had gone through all of this testimony, whether it would still show up on text or if the conversation was swiped out or whatever the Android equivalent of swiped out is. And so it was really hard for me to tell, but he was saying those weren't deleted. So I still don't know what to take away from all of that two-factor authentication conversation because it was so choppy in the way it was presented and it was so confusing.
Mr. Carroll, how much more do you have with this witness? Because you have a remote witness that's been sitting there all day waiting to testify. And if I have to take him out of turn.
I just talked to him, Judge. And I told him we may not be done.
But I would like to do that witness.
Would you?
Even if
Okay.
we have to take him out of turn. I assume her cross-examination is not going to be long. I just need to get you through your direct.
Okay.
So.
Have you already notified him?
No, we haven't notified him.
Yeah,
But
that's fine. I'm fine.
I
with
just
that.
he's been sitting there all day and I'd rather get him done. He's worried about, I think, losing electricity next week. I mean, there's just issues that
Right.
I don't want to
Okay.
stress your witness out and try to get them done today.
That's fine, Judge. I literally just talked to him and said, I'm not sure yet. So that's fine.
Okay.
I'm happy to do that.
How much more, how many more questions?
I Well, we have a couple of days to go through, Judge. So we're probably maybe hour and a half, 2 hours for him.
Well, then we need to stop with him and do
Okay.
your remote witness. If
Okay.
that's okay with everybody. All right, you can have a seat. Let's go ahead and get the remote witness.
The witness that was called is an audio expert, Nick Barrero. He comes in to testify that he did audio analysis of the hang up 911 call. And he talks about the fact that he looked at the short hang up 911 call where you can hear the automatic voice giving the time and date, the dispatcher, and 1.4 seconds of what he says is an apparent groaning sound or a groaning sound. Remember, Juliana testified that that was the victim, Joseph Ryan, after he had been shot on that 911 call, and that she had called too early. And Christine was like, call 911. And she just like responded and called 911. And he said he also reviewed an exemplar titled Lily 3 that had a dog barking and making some other noises. There's no foundation for that exemplar audio. So it seems that the defense wanted the audio expert to compare an exemplar of the dog. I'm assuming Lily's the family dog. We don't know. There's no foundation. And wanted him to compare that with a graph to the 911 call. But the expert who sat on Zoom from 10 a.m. Eastern until after 4 p.m. Eastern couldn't complete his testimony.
There's been a foundation objection relating to the Lily 3 file that you've received. So we're going to have to get evidence as to the foundation before we can continue on with your examination.
Okay.
I'm not certain when that will be, but are you willing to get back on at the appropriate time?
Yes, sir.
All right, is there any cross-examination based on?
Not at this time.
A couple things. Please use this extra time to reboot a little bit and get more organized. The wheels were coming off there, and I don't want to waste the jury's time anymore or witnesses' time, or for that matter, my time. Just remember that you are responsible for your record to keep it clean, not me, not Shannon. Okay, so please be wary of your exhibits and your numbers and what you are. Moving forward, I expect, and this is what I expect from all attorneys moving forward, I want all exhibits pre-numbered and in electronic format separately in separate files with the exhibit number already titled on that file, okay? And make sure you have all your witnesses lined up and ready to go. Does that make sense to everybody?
It does.
Okay, we've got it. And make sure, Mr. Carroll, I think we need all your exhibits from today. Did we get the video to you?
Judge, your clerk kindly provided the one item. I am still missing all of defense
Okay.
exhibits today.
So we need to send all the exhibits in those same separate files by exhibit number to the Commonwealth and also to us. When you send the exhibits to us, if they're not in the separate file.
Unless Judge A has a rule that we have not seen before, one PowerPoint can be marked as one exhibit, exhibit 10, pages 1 through 50.
Are numbered. Shannon stays here for 2 hours to get it all done so she can take care of it because she can't leave until all of that is
Which
taken
sucks
care
for
of.
her.
So you have to get
It's
it to us as soon
awful.
as possible. to take care of, but I just need more organization. I really do. Okay. Does that make sense?
So, that was Friday, day 7. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.